Well, good afternoon, everybody, and thank you for joining us today for the first part of the educational tract on estate planning. My name is Kieran Leva. I'm a senior financial consultant here at Seneca Lyons and Associates Private Wealth Management. Our family office provides comprehensive and complete financial planning services, predominantly to successful business owners and professionals, as well as to high net worth families with complex financial planning requirements. We provide important insights to help our clients better understand and plan tax effective and efficient strategies to meet their family's goals while alive and to transfer their family wealth, including their business, to the next generation. The first installment in the series in today's Estate Planning Educational Tract presentation aims to introduce important aspects of family, estate, and tax laws with the aim of meeting your intergenerational wealth transfer goals while getting more money safely into your heirs' pockets and helping them keep it. So today we will cover an overview of what an estate plan is and the role of the will and other key components. Next, we'll dig deeper into the various tax implications that we should be mindful of. And finally, how you can get started and any follow-up questions that you may have. So a couple of notes before we begin. Our presentations are interactive, so we encourage you to use the Q&A function on your screen if you have any questions. We'll get to as many as we can at the end of the presentation. If we do run out of time and we can't get to yours, we'll follow up to all the attendees if the questions are general in nature. If your question is more tailored to a specific situation or circumstance that you find yourself in, we'll get back to you individually. Finally, as a bit of a disclaimer here, the contents of today's presentation are meant to be conceptual in nature and should not be taken as specific advice. Everybody's situation is different and unique, and any ideas outlined today would need to be considered in the context of your individual circumstances and may not apply based on the particulars. So before we dive into the agenda and begin the presentation, I will take a moment to explain how legacy planning works and how sharing your wealth fits into a financial plan and the process that we take our clients through. So legacy is a specific component of a financial plan, but it's not in and of itself a financial plan. Saying you want to give X to your heirs through my estate is a nice sentiment, but if your retirement has not been tested to ensure its success, your estate may not have enough to meet your estate goals. What if your investment returns aren't what you expect? What if inflation is higher in retirement than forecasted? What if you get sick and you can't work leading into retirement? These are all important factors that we need to consider. So one of the core principles of our family office is that the financial planning should be comprehensive. To ensure our clients' plans are successful and on track, we take the time to understand a multitude of factors and the part that they play in the financial plan. So whether it's managing your cash flow, planning a major purchase like a home or a cottage, preparing for an unexpected event like death, disability, or illness, reducing your tax burden, or planning for and transitioning into retirement. These are all important components of a proper financial plan. Our job is to work with our clients to ensure that they understand how all these pieces fit together to ensure a cohesive plan is in place that creates certainty in all areas of their financial future. They're really at the center of everything that we do for our clients. Additionally, as a family office, we're happy to include all family members in the planning process, often including and providing financial information to our clients' kids or parents, and sometimes even preparing financial plans for their benefit as well. So here's the agenda for today, which we'll jump into shortly. We have dying intestate, which essentially means what happens if you pass away without a will. Death and taxes, some of the only guarantees in this life. Avoiding and reducing probate and what probate is. Reducing the tax bite or tax bill and some tax strategies that we can explore. The estate planning process as a whole. Trusts and how those may fit into a proper estate plan, and how to effectively settle an estate in a reasonable amount of time. So there was a recent study conducted by Angus Reid that showed only 48% of Canadian adults have a will, and worse yet, only 35% have appointed powers of attorneys. So not great numbers here. Our goal today, one of our goals today, will be to impress upon you the importance of being prepared with a solid estate plan and well-structured estate planning documents. So, presenting the first installment of the Estate Planning Educational Tract is Pierre Senecal, Executive Financial Consultant and Senior Partner at Senecal Lyons and Associates. Pierre has decades of experience as a business owner in the fields of manufacturing, land development, construction, and of international trade and finance. Pierre specializes in providing advice on financial, tax, and estate matters to our clients. So, in addition to being a CPA, Pierre holds many industry-leading designations, such as his CFP, or his Certified Financial Planner designation, his Trust and Estate Practitioner designation. He's a Certified Executor Advisor, and a Master Financial Advisor in Philanthropy. All these designations make him one of the top estate planners in the industry. So now that I've pumped Pierre's tires up, I think it's appropriate that I hand it on over to him. So take it away, Pierre.
Thanks, Kieran. And thanks everybody for showing up today. We'll hope to make this interesting and not too long for you today. I'd like to start, before we get into the meat of this, by clearing up a few misconceptions that we find pretty prevalent when we start talking about estate planning with clients. First of all, just to be clear, when you're alive, your will has no effect at all. It has no authority. Powers of attorney are what people can produce, or you can, give people that power to act on your behalf and to make decisions for you while you can't, or while you are not, not in a position to do so. When you die, however, that is when your will takes over. So the moment you die, that instant, the powers of attorney are of no longer of any effect, and anything that happens from there on is the executor's job. So after you pass away, the person who was your power of attorney the previous instant cannot give any instructions anymore. So a lot of people don't understand that. The other thing we're going to talk about is dying without a will, or intestate, so no will. A lot of people feel that, do I really need a will? If I die, my spouse will inherit everything. Well, in some cases that might be true, but in a lot of other cases, it is not true. So if you are married and you have no children, yeah, that's right. Your spouse will get everything. If you're married with one child, however, this is how it works. The spouse inherits the first $350,000 of your assets, and the balance is split half and half between you and your child. Now, you cannot manage your child's assets if they're a minor, so you might need a public trustee there, and they will step in to make sure you handle the child's funds are handled. If you more than one child, then you get a third, the children get 2/3. Here's the thing, if you're not married, because you're a common law spouse, children get everything, you get nothing. If you're not married and no children, deceased parents inherit all. We were onboarding a client a few years ago, and the person was in the construction industry, divorced, had 2 teenage kids, but he was in a common law relationship, a very stable one for the past 10 years at that point. He was in the construction industry, so he thought it was a good idea to transfer ownership of his sixplex in Toronto. You can have a sense of what that was worth, and his cottage in Keswick, to his common law spouse. And she had no kids of her own. So I had to ask him how well he got along with his mother-in-law. And he said, why? Well, I said, if something happened to your spouse, your mother-in-law will be your landlord at this point. She will own everything. To his shock, obviously. And he asked, what could I do? Well, you can either get married or write a will. And obviously they ended up doing both. So goes down the line, it's not clear who inherits if you do not have a will. Other considerations that people should consider here, there's no will. So you need to get a court appointment. That costs money, could take a few months. And otherwise, a public trustee will handle everything, and that may not be in your best interest here. In the best of times, heirs will squabble over inheritance. That's with your direction. Without any will or direction, trust me, it gets worse. Typically, there are higher costs, legal costs to appoint the executor. You might be required to pay for and get an insurance bond issued to make sure that you follow the laws, and otherwise they will pay. You definitely will need probate. We'll get into that later. You will not be able to give directions on the investments or everything. You will not be able to make tax elections, so potentially higher. There are all kinds of things that could happen. And what about your kids, right? There's no direction there. So a lot of people think that, it costs a lot to make a will. I would suggest it costs you a lot more if you don't. Another thing just to understand also before we get into the meat of this is taxes. The two certainties in life, death and taxes. And obviously, if you don't plan right, you could end up owing a lot of taxes, a huge tax bill when you pass away. So how is an estate tax in Canada? Well, first of all, there is no estate tax per se in Canada. Many countries, the USA, many European countries, will tax you on what you own when you die. That doesn't happen in Canada. You might have a $10 million mansion, and if you were in the States, if you're an American, you owe tax on that when you die, not necessarily in Canada. In Canada, when you die, we have two taxes. We have the small tax and we have the big tax. The small tax you've probably heard of is the probate fee, right? Estate administration fee, as they call it. We call it probate. That's a small tax. We'll talk about that in a few minutes here. Let's talk about the big taxes. I think that is the most consequential one at the end of the day. When you die, everything you are deemed, it doesn't happen, but you're deemed to have sold everything you own a moment before you die. So you sell it at what it's worth at that time, right? You had a cottage, paid 50,000, it's worth $1 million. You are selling it for $1 million. And at that point, you have to pay tax on the capital gains. You are then deemed to have repurchased them for $1 million, in this case, right after you sold them. So bottom line is, you need to pay tax on capital gains the moment you die. And also, if you're in business, you may have taken amortization or capital cost allowance, we call. That is 100% taxable when you return. Also, your RSPs and your RIFs, you are deemed to have taken all of them out that day. So if you have $500,000 make it up in your RSP, your payday, the day you die, you just have a $500,000 taxable income at obviously the highest tax rate possible. We'll be looking at strategies to avoid that throughout this seminar, but just so you know, that's how it is. So let's talk a bit about the small tax, right? A lot of people think, want to avoid probate. Probate gets a very bad rap, but it has its uses. So probate, just to be clear, is a procedure by which you go to the Superior Court, in our case of Ontario, and the court, you ask them to formally approve that the will is their last valid will, confirms who the trustees are, the executors are. But the real thing is it protects third parties. For example, if you come to see me and say, hey, there's $1 million in my account, in the account of the person for whom I'm the executor, here's the will, please distribute the money. Now, I have no certainty that that is the last and valid will. So if I give you the money, I transfer the monies as you ask me to, and then lo and behold, there's another will that comes up that was done a few months or a few years later, I might be held personally liable and my institution liable to pay, to pay the money to the rightful heirs. So in order to protect myself, I will want to see this probated, because if the Superior Court says this is the will, even if you find another one, I'm protected. So that's why most financial institutions, to protect themselves, will need the will probated. If you want to, in most cases, not in all cases, if you want to switch title to a property, you will need probate, because the land registry office will need that. So what does it cost? Well, the first 50,000 of your assets is free, and then call it 1.5% on everything else. So $1 million, $1 million home, for example, or $1 million asset will cost you $15,000. Obviously, for small estates, they do have a bit, quick processes here. So there are a lot of things people do to try and avoid probate. There are good and bad strategies. For example, of a bad strategy, we had a client once who we found out after we onboarded the client that the client's mother had died about a year earlier, and the house was worth about, I don't know, about $750,000 at the time. So he had a friend who was an appraiser. He had the house appraised for the purposes to $250,000. So basically saving the probate costs on $500,000. It's illegal, but he did it anyways. Well, he saved $7,500 in probate costs. But then as soon as he sold the house for $750,000, and guess what? He was stuck with $500,000 of capital gain, on which he had to pay about $125,000 tax bill. So it cost him $125,000 to save $7,500. You can't win in that. So there are ways, however, that bad ideas, but there are good and bad ways to avoid probate. That wasn't a good one. A lot of people will give things before they die. Well, the problem with that is you've given it away. It's not yours anymore. If that's the intent, that's fine. But if you're just doing that to avoid probate, bad idea. And then don't forget that there's capital gains issues, because even if you give it away for free, the government will consider that you've gave it away at full market value, which means that if it's not your principal residence, you gave the cottage to your kids, there will be tax to pay that day. And if it is your principal residence, the good news is there's no tax to pay that day, but as the value grows in your kids' hands while you live in there, there will be tax to pay on the profits. Another thing that people do is they add children as owners. Well, again, under the new laws, you might have to produce a trust tax return going forward. It's unclear. But again, same things. You potentially lose ownership. What if your kid, your child separates? How does that affect the matrimonial property if you put the cottage in their name or you added them as owners? What if, somebody sues your child? Well, that asset is half theirs because you put their name on it. And again, potential capital gains. So there are all kinds of reasons why, if you're going to do this, let's have a good look at it. Probably not the best of ideas. There are better strategies. For example, you have an RSP or insurance policy or whatever, rather than having it go to the estate. Your TFSAs, you can designate beneficiaries, so the money goes directly to the people you assign there. Obviously, you have to be very careful when you do that. For example, if you have 2 kids and your kids have kids, and you say, my 2 kids are beneficiaries to this RSP, make it up, or to this insurance policy, and one of them predeceases you and leaves kids behind, well, because you named beneficiaries, 100% of the amount will go to the surviving child, and the deceased child's kids gets nothing. So if your thought is, well, if one predeceases you, you want their kids to benefit, this won't work. So you got to think about that. Another strategy that we've used a lot, especially with business owners, is you can actually have 2 wills. So for example, I'm a business owner. I have 2 wills. One that will handle anything that needs to go through probate. So I will pay probate on that. Anything that does not need to go through probate. So it does not need to go through a third party. So it could be art, jewelry. More importantly and more common, shares of my private company. Does not have to be probated, because really to change the ownership of the shares of the company, all I have to do is to have an insert in the minute books and the right signatures internally, and the shares change hands. There are tax consequences to that, probably, but you don't need to go through probate. Again, the one message here, at 1.5%, probate is a small tax. Bad planning could be a lot more expensive than 1.5%. It could be a rounding error at the end of the day. So let's look at reducing the big tax. And to give you an idea of what this could look like, if you can see this is, one of the first things we do when we work with clients is we say, okay, if you had died last night, what would have the tax bill have been in your current situation before we change anything? And, you know, obviously you have their home. Yeah, it grew in value, but that's not taxable if it's their principal residence. However, they do have rental units. And the rental units, well, if it's worth more than it was, you got to pay capital gains tax on the capital gain. And if you amortize it for tax reasons, you have to pay that back to the government, whatever you saved. Your RSPs go in, your TFSAs are not taxable, so that's good. There's capital gains on your investment accounts if there are profits in there that you haven't realized. And obviously, if you have a company, it gets a lot more complicated. It could be very costly. So in this case, you know, $15 million estate probably could come up to a three to $4 million tax liability. So our job is to make sure when we look at that, well, you have the liquidities to pay it, right? Your investments are liquid. You can use that to pay for them. But if all you have is real estate, you won't have any money to pay the taxes if you don't have enough liquidity. So something to think about. The other thing I just wanted to mention here quickly, this is obviously part of a few other webinars we give, but if you have a business, let's say you have a corporation, in this example, let's call it a holding company. You have $4.25 million worth of investments over the long term. They cost you $1.75 million when you did them. There's real estate in there. There's all kinds of things. So your company's worth $4 million, for example. But you know, like most people, you start a company, you issue $100 of shares, and then you hope it'll grow from there. So in this case, your $100 company is now worth $4 million. So when you die, you are deemed first level, there are three levels of taxation. You are deemed to have sold your shares. So $4 million. So call it almost $4 million in capital gains, half of it taxable, 53% tax at the top rate in Ontario. So the day you die is just because you own the shares, you owe $1 million in taxes. But if you need the money out of the corporation, well, you got to sell your investments in the corporation. So if you sell them all, there's $2.5 million of capital gains. Now, good news is half of that is not taxable and could come out tax-free to the estate, so that's good. But you still have to pay tax on $1.25 million. So it's 50% tax, but then when you dividend it out, you get a rebate. So there's $250,000 of taxes that are owed there. But that's fine, but the money is still, that $4 million is still in the corporation. So you got to take it out to give it to the estate. Well, that's a dividend. That's a third level of taxation. So by the time you pay the taxes on that, another 1.3 million, just realize that your $4 million company, when you die, 2.6 million or two-thirds of it goes to the government and a third goes to your heirs. Now, a lot of that could be avoided with good planning, both before and after you die, but just be aware of the tax burden. So when we say that the tax burden is pretty intense, it could be that. So how do you avoid some of those? And it's things we do with most of our clients when we have a look at their financial plan. Like Kieran said, nothing's in a vacuum. Everything is sort of depends on every aspect of your plan depends on the other aspect. So, you know, very often, especially when people have large RSPs, we'll often say, hey, let's take money out before you die at a lower tax rate, even if you don't need to, and reinvest it. So pay tax ahead at a lower rate, 30% maybe, and avoid paying tax at 53% when you die, right? Spousal rollovers. When I die, because I was told I was going to die first, I could transfer everything, my RSPs, my assets, everything, my share of everything to my wife, to my spouse, and there will be no tax to be paid by my estate because they will tax it after she passes away, so she doesn't have to pay tax while she's alive. There are all kinds of charitable strategies. We have 2 webinars on charitable giving and philanthropy, a basic one and an advanced one, so I won't get into that, but that's another way to save taxes. We always jokingly say when you die, you have 3 potential beneficiaries. You have the government, you have your heirs, and you have charity, and we typically ask people to choose 2 of those because that's how it usually works. And then the other way to do it, and we'll get into it another time, but you can use investment, funny enough, as an investment, insurance rather, as an investment vehicle to actually transfer funds to the next generations in a tax-free or tax-deferred or lesser tax way, and it could be a very powerful tool. Obviously, investment is first and forward to as a risk management tool to make sure you have enough money when you pass away or when you're incapable of working, you have a disability or something. But basically, you can have the life insurance company pay your tax bill, or you can use that as a way to transfer funds intergenerationally. So for other estate tax planning opportunities, for corporations, you can have an estate freeze, which basically means that I have a company, I'm going to freeze my tax bill today, pay it later, but going forward, my kids will get that and they could deal with the increase in value in the tax when they die. So I'm freezing my tax bill today for the benefit of my kids. There are all kinds of ways to use trusts, family trusts for this. And then there's a lot of things we can do after people pass away, especially for private corporation. But and I said that it's tax-free to your spouse. If I die on January 1st and I have no income, probably it makes sense that I do pay some of the tax at a lower rate. So I might avoid some of that tax-free rollover to my spouse. When you die, you can do more than one tax return on that day, which most people don't know. You can end up with 2 or 3 tax returns, and every time you get the basic exemption, save taxes there. So hopefully I was able to convince you that it might make sense for you to prepare and have a will. Let's now look at how we would approach that with our clients. First of all, in the words of Stephen Covey, you begin with the end in mind, right? Before you start talking about estate planning and what you want to happen, I would suggest let's make sure that your retirement and lifestyle goals are secured. Kieran mentioned that initially. Let's make sure that we crash test your retirement plan and your living plan, and then let's start looking at how we can do this. Next thing we do is let's determine what your tax situation at death is and how we can minimize that. Every situation is different. There are always opportunity to minimize that if we know what's happening here. The other thing you want to see, what you want, basically try and decide what it is you'd want to see happen when you pass away, right? Do you have young children? Well, if need be, who do you want to raise them and who do you want them to manage their assets? Not necessarily the same person. Some people are great with kids, horrible with money. Some people are great with money, horrible with kids. So, you don't have to be the same person. The other thing is, would your family, be financially secure if you're no longer there? So that's a huge consideration. It's not only about writing the will, it's about making sure that your family is okay when you pass away. And if you're a business owner, and we deal mostly with business owners, with a lot of them, we need to consider a lot of things, right? Is your business active or is it a holding company? Do you have business partners we need to consider? Do you have more than one company? How are they structured? Do companies own companies? Do you own them all? Do you have a family trust in place? That totally changes the dynamic here. There are a lot of tax elections or decisions to consider before and to prepare for when you die. The other consideration people don't always think about, if I passed away last night, who's going to be there to run the business if I'm no longer there? Are the children involved? Are they ready to take over? And if only half your children or one of your 3 children is involved, how do you make it fair for the other 2, right? Everything we need to look at. So, as part of our process, we look at all that and many other things. I mean, we have a systematic way of going through this to make sure we address everything. But then we suggest to people to look at what we call the 5D approach, right? So the first 5Ds of estate planning, the first one is decide, right? Identify concerned parties, right? We need to consider your family dynamics, financial needs, taxation issues, equalizations, recombined families is a big thing. How do you remain fair in all that? If you have business partners or creditors, how do you do with that? Um, we need to be ready to construct a clear will that won't be contested by unhappy heirs or forgotten parties, because that'll complicate things and you're years into settling the estate if that happens. So once you've pretty much determine who you need to consider, then you need to start developing and thinking about different issues, right? Here are just a few of them. But, you might want to think about your funeral arrangements. Make sure your loved ones are taken care of, and if you have young kids, well, let's make sure there's enough money there to make sure they're supported till they're independent. For a lot of people, philanthropy fits in there. You need to think about executors, guardians, etc. Do you need trusts or not? So a lot of things to think about. And one of the things we often, as a third D, suggest to clients is discuss. They don't need to know the particulars, they don't need to know the amounts, but very often it's a good idea to discuss with your family, with your kids, what your thoughts are. You have two kids and you're going to leave the cottage, and to your surprise, one of them doesn't want the cottage. Well, it's good to know before you make your will, right? And then just letting them know that you're on top of this, and it's not necessarily an easy subject, but if you step back and you look at it clinically, we're all going to go through that at some point. And because you make your will doesn't mean it's going to happen soon. There's no correlation. It happens when it happens, but better to be prepared. And knowing you're on top of that goes a long way to make them feel a lot more secure. Next thing, obviously, with the experience of with the help of an experienced estate lawyer, write the wills and powers of attorney, right? You're never too young. As soon as you have assets, you need a will, you need powers of attorney. Who's your executor, your tutors and guardians, and who your heirs and beneficiaries will be, right? And your will should be reviewed regularly. We like to review anytime something major change happens, let's review your will to make sure we're on top of that. But the other thing that we like to do also is every 5 years, come hell or high water, let's have a look at your will. Is it still what you want? And the final D is distribute the estate, right? So that would be the executor's role. I won't spend a lot of time on that, just because we have a whole webinar, and it's the second one in our series that talks about the job of the executor. But, among other things that the executor has to deal with, pay the bills, do the tax returns, do the funeral arrangements, distribute the assets. And like I say, that is a very, very small list of what they want to do. Always remember that the executor is a job. It's not an honor. Be prepared to work. It's not an easy one. Now, one of the things that we want to talk about here, and let's talk about a few mechanisms and a few ways that you might want to consider as you're preparing for your will, right? We talked about trusts. Trusts could be either before or after, come into play before or after you die, but trusts are used by a lot of high net worth families and business owners and professionals. There are different types of trusts, like I mentioned. There are trusts that are set up and in operation before you die, bare trust. This could happen if you put your child's name on your assets. You might be creating a bare trust. And there are all kinds of other trusts that you mostly happen when you're alive, and they are in effect while you're alive. But there are some trusts that, although you create them before you die, you set them up, they don't come into existence until you die. So testamentary trust, which basically just means from your will, Henson Trust for disabled or challenged people, spousal trust, very often used when you have recombined families and you have stepkids and stuff like that, and insurance trust to avoid probate, but without necessarily having the funds go into anybody's hands specifically. So why would you use a trust? Well, very often I talked about recombined families. You have children of previous relationships, but you want to take care of your spouse, but you don't want to forget your kids. Spousal trust and different testamentary trusts are the way to go. If you have minor children, just be aware that under Ontario law, until they're 18, if you don't name somebody in your will and there's nobody appointed, the public trustee will manage their money. But the day they turn 18, that's their money. So I don't know about you, but when I was 18, probably not a good idea to give me a lot of money. I would have had a nice car and a few parties here. So just saying. The other reason you want to is to protect assets for your heirs from failed relationships or creditors. I often, tongue in cheek, but not, ask my clients if they're okay with having half of their estate go to their future ex-son or daughter-in-law, right? And the future X is the thing here. You can take precautions, and trusts help cement that possibility. And the other thing is trusts, testamentary trusts and different trusts, but mostly testamentary trusts, will help you pay less taxes, right? And let's just look at that and give an example of what that could mean. So let's look at an example here. So you have John and Joanne, married couple, and John passes away. John had an insurance policy for $500,000, and let's say it's invested and at 6% makes 30% income a year, right? Well, Joanne already makes $115,000 a year, so her tax bracket is already at 43%, which means that every penny she makes, every dollar she makes over and above that 115,000 will be sending 43 cents, 43.4 cents to the government. So without a testamentary trust, the inheritance is added to the heir's assets, and the income of the inheritance is added to the heir's future income. So now she went from 115 to $145,000 in income, which means that $30,000 is going to cost her an extra $13,000 in taxes. And again, I'm just reiterating that. Don't forget that the children, if you leave them money one way or another because you have no will or because you left money in the will, the public trustee will handle their money for them until they're 18. If instead John had left the money, instead of leaving it to Joanne, leave it to a trust. So triangle here for me is my symbol for a trust. But Joanne is a trustee, and the trustee is the one who makes all the decisions. Really, she can spend the money, she can do what he wants. So it's the same thing as if it were in her pocket, but it's not hers. And the beauty of that is she can turn around and say, well, Julie and Johnny, my two kids, I'm going to allocate $30,000. I'm going to allocate $12,500 each, which is basically means that they're not going to pay any income tax on that. And I'll allocate $5,000 to me. She can do it however she wants. And she could even turn around and give it all to Johnny and Julie. There are ways to do that, which means that all of a sudden that $30,000 only attracts tax on the $5,000, so $2,100, $2,200, which means she saved almost $11,000 in taxes. The beneficiaries could be restricted to the downline, which means that any child, so could be your spouse and any child born or unborn at the time, you decide on the rules on who can be the beneficiaries and get the taxable income and the investments out of there. If you have minor children, the inheritance could be managed by somebody you trust, either your spouse or somebody else, especially if both of you were gone. And at some point, when they're older and capable, you can say, well, when they're 30, they can become trustee to their own trust and manage their own money, but keep it in there. And then again, like I did here, you allocate your income, the taxable income, to the lowest taxed person. And the other thing I mentioned earlier helps protect your assets from creditors, right? If Joanne gets sued, it's not her money. That $500,000 is not hers. It's held in trust for somebody else, so nobody can attack that. And obviously, if she remarries and she separates, well, it's in the trust. It's not hers. It's not part of the family, the matrimonial property. So another big advantage here. So advantages, lots of advantages, from a tax to a creditor to protection, and a lot of, protects spendthrift, right? If your kid can't manage money and they're going to spend it all, well, you might want to leave it in trust and have somebody else manage it for them. There are all kinds of things you can do with that. But to do that, the planning needs to be done in the will. So it has to go through the will. So it means obviously probate, which protects everybody at the end of the day. Disadvantages, well, obviously, if you have a trust structure in your will, you might be paying a few $100s more. There has to be administration, tax returns for the wills every year, but if there's enough money in there, it's really worth it. Let's give you another example of protecting the estate. One of my favorite stories, which basically is a bunch of stories together here. It's not just one couple, but in my story here, the elderly couple, um, passed away and left $1 million to their daughter, Jennifer. And Jennifer is married to somebody I'll just call the son-in-law for now. And they have a kid, Timmy. So she inherits that, but she soon after passes away. So that $1 million now belongs to the son-in-law, who's there for him and his son, Timmy. But there's a reason the son-in-law was looking the other way. I mean, he had his eyes on somebody else, a new young lady with a daughter of her own, and they get married. And then he passes away, and he left everything to her. Well, she never liked Timmy anyways, and she has no obligation for that. So poor Timmy at the end of the day has nothing. If instead they had left their money in trust, and they said, rather than to Jennifer, and they said at that point, the beneficiaries of the trust are Jennifer and her downline, right? Her issue, as we say. Then when she passed away later on, Timmy would be the only beneficiary of that $1 million, never would have gone to her husband, and obviously never would have been lost. So another thought here, and we get this often, is who should be your executor, your guardians and trustees? Well, for executors, we would suggest a few things. First of all, you want them young enough. I mean, your uncle, by the time you're 70, might not be in a position to take care of that, or your parents. You want them residents of Canada and ideally residents of your province, because all these here are managed provincially. And if you're out of province, and especially out of country, the government might say, pay for an insurance bond to make sure nobody runs away with the money here. You want somebody who's a good administrator because, it's an administration job, right? And somebody who's used to comfortable dealing with financial institutions and governments and everything. So they need a basic understanding of finance and tax, we hope. They need to understand the experts they work with and make financial and tax decisions. So they could work with accountants and lawyers and make sure they do that. So they need to have the competence, time, and energy to manage the estate. And funny enough, they need to be forceful enough to push back on aggressive heirs who want everything today, although it's not available today. So we really suggest that you discuss with the candidates and maybe have alternatives, right? If you name me or name anybody as an executor or whatever, they might say yes today. When the time comes, they're allowed to say no. So you might want to have alternates, at least one or two levels of alternates. They may not even be there or able to at the time. You don't know. Guardians and trustees. So now we're talking about the children, right? Guardian will raise your kids, right? Trustees will manage their assets. They could be the same person, but they don't necessarily have to be. You want them young enough, willing and able to deal with children or their assets. Realize if you have young kids, it could be a long-term commitment. You're talking about your kids here, so I would suggest you think about somebody who shares your values and principles. And again, take time to discuss with the candidates and think of alternatives. If one can't, maybe somebody else can. Few last thoughts here. We've seen estates settled in 3 months. We've seen estates, well, a few years in now, they're not settled yet, right? So what are the impediments to settling an estate? The first one, funny enough, is surprise executors. Surprise, you're the executor. Well, I didn't know. I have no idea of the person's situation. And even if I do, where's the will? Where's everything? I have no idea. So make sure you talk to people you want to be executors or you're considering and make sure that, It's not a flat out no before it even happens, but they know what to expect, right? They don't need to know what's in your will, but they need to know they're the executors and maybe where their will is. When there's no estate planning, that is another one. And estate planning, as I said before, it's more than just having a will. It's being prepared for everything and make sure that you thought things out as best you can. Is your will current? Are the instructions clear? Very often we have situations where people say, "Oh, no, it's very easy. I want this to go this way." Well, wait a minute. There are people involved. There are personalities involved. There are all kinds of tax rules that you don't know anything about. Always reminded of this story where person died. At the end of the day, he had two assets: a $700,000 RIF and a $700,000 cottage, so a RIF RSP. So the daughter wanted nothing to do with the cottage, and the son wanted everything to do with the cottage. So he said, well, 700,000. He put his daughter as beneficiary to the RIF. So when he died, the money went directly to her, and he put him through the estate, through the will, as the inheritor of the cottage. Well, problem is, the $700,000 check was sent from the financial institution to the daughter because you're not allowed to withhold tax. I mean, the RIF doesn't have to pay tax, the estate does. So the estate, well, she got her $700,000 check. The estate got a $350,000 tax bill on that RIF. So the estate had to pay it, not her. And there was capital gains on the cottage, so add another 150 to that. So basically, the son inherited a $700,000 cottage and a $500,000 tax bill. And when you ask the daughter, because, hey, wait a minute, dad made a mistake, she said, no, that's what dad wanted. We talked about it. That's it. Too bad. So again, estate planning is more than just a will. Unlocatable information, a lot of people have. Where's the will? You have all the legal documents. Executor will require the purchase of the house, the whatever, the life insurance policies, everything, right? You have a list of all subscriptions, accounts, passwords. Do you want your Instagram to go on forever, whatever? What we suggest often is, hey, take the time to prepare a binder with all the required information and keep it in a secure location that the executors know about. Could be a safe at home. It could be anywhere, right? It's in this nook. They should know where it is. And another thing that we find that helps a lot is consolidating bank accounts and investment accounts. There's nothing worse than people having, because they think it's safer, they have 5 different bank accounts, so you have to deal with 5 different banks. And my experience is, unless you go up 4 or 5 levels from the teller, nobody knows what to do, and they're putting all kinds of obstacles in the way just because they don't know any better. And a lot of people have investment accounts everywhere, and then getting everything consolidated becomes a nightmare because everybody wants to hold on to things as best they can, and they want to convince the executor to deal with them and somebody else. And so at the end of the day, rather than taking 3 to 6 months, if you haven't consolidated, expect this to be a very long process. So again, with a bit of planning, it could be settled in 6 months. And very often when we talk about consolidating investment accounts, well, at the end of the day, if you have your investments with 4 or 5 different advisors, you don't have diversification. You have 4 or 5 different people working off the same markets with the same investment. So you're just, for some reason, duplicating and more your strategies, and you're not getting diversification out of that anyways. So final thoughts, things we need to know when we work. Do you have a will? When did you last update it? Do you know where it is? Does it really do what you think it does? And often it doesn't. And are you taking advantage of all the tax elections and tax strategies you can? Have you given power of attorney for property? And have you given power of attorney for personal care? Right? Power of attorney for property. you designate somebody who can make decisions and sign in your name when you can't, and a power of attorney for personal care. And these powers of attorneys, again, we talk about that in another webinar, so I didn't go in depth into that, but they give people the authority to give um, directions on healthcare, on where you live, or any type of healthcare and medical and everything. And the power of attorney for personal care uh, is not in power. I mean, if you can give a decision, they can't do anything. But a power of attorney for property could be in effect while you're able to do it anyways. So we'll talk about that in another seminar. And make sure that you know where to get help. I mean, for our clients, we are certified executor advisors, and our clients know that they could come to us for help in managing and settling the accounts. We always make sure that our clients introduce us to their executors, and so they know who we are, we know who they are, and we can, it just facilitates the situation when that happens, right? So, in a nutshell, this is sort of the thoughts that we wanted to put together here. James, in the few minutes we have left, have we received any questions?
Thanks, Pierre. Yeah, just filtering through the questions here as they come in. Just a reminder to anybody, if you have a question that's of a general nature, we're happy to address that quickly right now. If you have anything a little bit more specific to your personal situation, feel free to reach out to us. And we'll be happy to address that offline. Pierre, while I gather the questions and kind of sort through everything here, I'm just going to take a quick moment to familiarize some of our attendees with our team and also with IG Private Wealth Management. Could I get a slide forward, please?
Sure.
So for those who haven't had the chance to be introduced to me, my name is James Lyons. I'm one of the partners with Senecal Lyons and Associates. You've already heard from Pierre and Kieran today. You'll see the rest of our very talented team here. We work together as financial planners to serve the financial planning, investment, mortgage, insurance, whatever the needs of our clients are. We work together to develop a financial plan that covers all aspects of their financial life and propose solutions to achieve the goals that they're looking to work towards. Can I get a slide, please? When we work with clients at Senecal Lyons and Associates, we're not looking to essentially take over anybody's role. What I mean by that is our team is uniquely situated to work alongside our clients' already trusted advisors, whether that's an accountant, a lawyer, another investment advisor, whatever the case might be. We work in tandem with our client and their already existing advisors to ensure that there's cohesion in the strategies that we're putting in place and that everybody is on the same page when we're executing a strategy. A great example would be, we're talking about estate planning today and how that fits in as part of a financial plan. We would not be doing a great service to our clients if we weren't collaborating with their estate lawyer to talk about all the tax implications of their investments, their insurance policies, their properties, all of those types of things. So when we work with our clients, we work not only with them, but with their trusted advisors. And when required, if we do need to bring in some of our in-house specialists, whether that's corporate tax accountant, an estate lawyer, an advanced financial planning specialist, we have those people on retainer as part of our business. So when you retain us, you also retain them. Can I get a slide forward here? I'll actually get you to go a couple forward here. So talking about IG Private Wealth Management as a company, Senecal Lyons and Associates is a practice operating under the IG Private Wealth Management banner. IG is actually going to be celebrating its 100-year anniversary next year. It's one of the biggest financial planning companies in the country that's partnered with a lot of the most experienced and prevalent service providers in the industry. So you'll see on the life insurance side of things or the insurance side of things, a lot of names that you recognize there, like Great West, Canada Life. When it comes to asset management, we've partnered with companies like, take your pick there, JP Morgan, BlackRock, T. Rowe Price, to name a few, the biggest insurance partners in the country, some of the best banking partners in the country. IG's been uniquely situated within the financial services segment to partner with a variety of different service providers to ensure that whatever solution makes sense for our clients, we have top of the line providers that are able to provide those products that are required for their financial plans here. A couple slides forward here. So IG's made a commitment to, just back one, please. IG's made a huge commitment to giving back to the community. You'll see that we are the target sponsor for the Walk for Alzheimer's and a number of other organizations here. About 5 years ago, our team also opened our own charitable giving fund, which grants a portion to charities in our community that we care about here. Just gathering the last couple of questions here. As we work through the questions, just want to, Pierre mentioned this a couple of times throughout the presentation. We do like to put these presentations on periodically on what we find is relevant and helpful information. So you'll see the upcoming presentations for the rest of the year here. If you have any interest in those subject matters, please feel free to register through our website. You'll also see that we have our presence on social media there as well. Okay, so coming back around to the questions here, Pierre, I've got a couple of interesting ones here. So just harkening back to talking about the qualifications of an executor.
Yep.
What if you're in a position where you don't have someone that meets the qualifications that you think you would need to execute your estate?
Well, obviously, there are always solutions in that case. They are a bit more costly. There are professional trustees. We know of a few of them who are good. Concentra Trust, or even the banks all have their trust companies too. You could hire a professional trustee who will follow pretty much the words of your will. They, however, do not necessarily understand the dynamics yet. They will eventually of the family and of who's who. But that always is an alternative. And again, we like to insist, really think about this. Is there anybody? And if not, well, that might be the final way to do that. Obviously, for guardians and trustees, I would suggest that you find somebody, because you do not want the public trustee to handle your children's thing. Now, a professional trustee could handle the kids' monies, but they will not be raising your kids. So give that some thought.
Excellent. A couple other questions here. I know we're right up against the time, so I'm going to talk fast here. My favorite question when it comes to estate planning: if my estate plan is simple, can I just do it myself?
I mean, nothing's stopping you. There are all kinds of ways you can do your will. It could be holograph. You can write it, you can write it yourself and sign it, and there are all kinds of ways of doing it. Problem we find in there is I have yet to find a simple situation, and I've been doing this for years. We often oversimplify, and by doing that, we cause more problems than not. You can go online and for, $50 or 20, whatever, get a will and just put your name in there. But I bet my bottom dollar that it will be one of the worst experiences for your heirs. So things are never as easy as they seem from a tax perspective, from a legal perspective. I told you about that client who decided to give the cottage and the RIF to his 2 children. Well, there are consequences he didn't think of. So at a minimum, speak to an advisor to make sure you cover all the angles. And then again, there are clauses in there, right? If you leave money to a child, there's no trust. Well, maybe you need a clause in there that says that in your will, that says that the money stay in the estate, in the trust, until the children is a certain age. If you don't say that, it doesn't happen. The trust has to be, technically, the estate has to be done within a year. Never is. You need to give permission to the executor to, well, we say at least 3 years, because that's when you get the good tax treatment, because there are tax advantages to keeping in there for 3 years, but you don't have to, but you want to give them the permission. So there are all kinds of things. So there is no, in my experience, simple will.
Wonderful. I realize we're up against the time here, so maybe I will just address one more question here quickly, and then we'll reach out to any of the questions that weren't addressed after the presentation. The question was, will this be available after? Yes, typically we post all of our webinar content to our website. Usually it will be up there by the end of the week. You are also in a position where you could view any of our previous webinars on a variety of subjects on our website there. So if you're interested in any of the content that we're producing, I'd invite you to check out the website, and you can see our full webinar slate there. So thank you everyone for joining us. I hope you found it informative. Pierre, thank you for sharing the wealth of knowledge and making a very complicated subject a little bit more clear. And I'd like to, again, welcome everybody to participate in our upcoming webinars. And if you have any specific questions, please feel free to reach out and we'd be happy to address them.
Thank you, James. Thanks, everybody. Have a great day.
Have a great day.